Today I'm breaking down the biggest myths about Florida non-competes and showing you exactly what the law actually says. By the end of this video, you'll know exactly how to evaluate your own non-compete agreement and whether you actually need to worry about it. I'm Santiago Cueto, board-certified international business law expert and best-selling author, and I've handled dozens of non-compete cases in Florida. And here's one. Just imagine you just got a job offer, great salary, better title, the career move you've been waiting for. Then you remember you signed a non-compete agreement at your current job 2 years ago. You barely read it. Now you're wondering if you're about to get sued. This exact scenario plays out hundreds of times every single day in Florida, and most people have no idea what's actually enforceable and what's just legal theater designed to scare them into staying put. Let's start with the biggest myth of all. Non-competes aren't enforceable in Florida. Wrong. Florida is actually one of the most employer-friendly states when it comes to non-compete agreements. California banned them almost entirely, but not Florida. Here, they're valid and courts will absolutely enforce them if they meet specific requirements. But here's where it gets interesting. The law changed in 2023. Florida created a presumption of reasonableness for certain time periods. 6 months or less, presumed reasonable. Between 6 months and 2 years, could go either way. More than 2 years, you better have an incredible justification. Now let's talk about myth number 2. Non-compete is enforceable because I signed it. Not so fast. Just because you signed doesn't mean it's valid. Florida law requires legitimate business interests. Your employer can't just say they don't want you working for competitors. They need to prove they have protectable interests like trade secrets, confidential business information, substantial relationships with customers, or specialized training. I had a client who worked as a receptionist. She signed a non-compete. Her employer tried to enforce it when she left for a competitor. We got it thrown out in just 2 weeks. Why? She had no access to trade secrets, no specialized training, no customer relationships. The court said the employer had no legitimate business interest to protect. Case closed, done. Myth number 3 might surprise you. I can't negotiate my non-compete. Actually, you can. Before you sign anything, you have leverage. After you sign, much harder. I've negotiated dozens of these agreements. We've reduced geographic restrictions from statewide to just to single counties. We've shortened time periods from 3 years to 6 months. We've carved out entire job categories. Most employees don't even try. They assume it's take it or leave it. That's exactly what employers want you to think. Now, if you're getting value from this information, do me a favor, hit that like button right now and subscribe to this channel because I break down Florida business law every single week. The knowledge you gain here could save you tens of thousands of dollars in legal fees down the road. Now let's move to myth number 4. I can't just ignore my non-compete and hope they didn't notice. This is dangerous. Florida employers can get injunctions. That means a court can order you to stop working for your new employee immediately. They can also sue you for damages. I've seen cases where employees had to pay back salary to their former employers, career destroyed, bank account drained, all because they thought they could fly under the radar. But here's the flip side. Many employers use non-competes as psychological weapons. They never intended to enforce them. They just want you to think twice before leaving. How do you know the difference? Look at their history. Have they sued former employers before? Do they have the resources for litigation? Sometimes the threat is scarier than reality. Myth 5 is about consideration. My employer can add a non-compete anytime they want. That's false. In Florida, if you're already employed, your employer needs to give you something new in exchange for signing a non-compete. Continued employment isn't enough. They need to provide a raise, promotion, access to confidential information that you didn't have before, or something else of value. I've seen employers hand existing employees non-competes with zero new consideration. Those agreements are worth less than the paper they're printed on. Now here's a myth that costs people money. I need to hire a lawyer to fight my non-compete. Well, that's not always true. If your agreement violates Florida law on its face, you might be able to handle it yourself. But here's my advice. Get at least one consultation. Most employment attorneys offer free initial consultations. 30 minutes can save you from a massive mistake. Now, the last myth I want to address is about geographic restrictions. My non-compete says Florida only, so it's automatically reasonable. That's not true. Florida's a big state. If you work in Miami and your non-compete prohibits you from working anywhere in Florida, that's probably overbroad. Courts look at where you actually worked and where your employer actually does business. A statewide restriction for a business that only operates in 2 counties, that's not going to fly. Here's what actually matters. Florida courts apply the blue pencil doctrine. They can modify overbroad agreements to make them reasonable. They can't rewrite them completely, but they can strike out unreasonable parts. That 2-year restriction might become 6 months. That statewide ban might become a 50-mile radius. So what should you do right now? First, find your non-compete agreement and actually read it. Look at the time restriction. Look at the geographic restriction. Look at what activities it prohibits. Second, understand your leverage. Before you sign, you do have options. After you leave your job, your options narrow significantly. Third, document everything. If your employer claims you have trade secrets, well, what are they specifically? If they claim customer relationships, did you actually build those relationships, or did you inherit an existing list? Non-competes in Florida are real. They're enforceable, but they're not bulletproof. Know your rights, understand what you signed, and don't let fear keep you from the career move you deserve. Now, if this video helped you understand Florida non-compete law, show your support by liking this video and subscribing to my channel. I post new content every week breaking down the legal issues that actually affect your business and your career. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.